How to successfully enter into a contract. When it comes to business contracts, there are a few things that you want to keep in mind to ensure your contracts are both effective and legally enforceable. Legally speaking, a contract must have an offer from an offeror, an acceptance from an offeree, and an exchange of value, e.g., money for goods. Any contract with these elements will likely be deemed legally enforceable in a court of law should a dispute arise. Though it's not required to put your contract in writing, your important business arrangements and agreements should be put into writing to protect your interests. Simply put, oral agreements are too ambiguous and difficult for a court to enforce. This means you are basically at the whim of the party you made the agreement with when you make an oral contract. While this is fine for small things like getting your tires rotated on your car, it can't be how you run your business. Let's go over a few more basics that you'll want to keep in mind when you draft contracts for your business. Business Contract Basics. There are volumes written on contract law, but let's instead start with a few basic rules that any business owner can benefit from following. 1. The contract must include 2 or more parties and be signed and agreed to by all parties. 2. There must be an offer made by one party, the offeror. 3. The contract must be legal and moral. In other words, you can't sign a contract that requires you to steal money. Such a contract would be found void. 4. The offer must be accepted by the offeree. This means no counteroffers or rejections. 5. There has to be an exchange that takes place between the two parties, like paying money for services. Now, this is just a short little list. Depending on the type of contract you are working with, there may be other essential things you also want to keep in mind. Keep in mind that each state has slightly different contract laws as well, so these things can vary a little from state to state. Some things to keep in mind with offers. As we discussed, there must be an offer and acceptance for a contract to be valid. One thing to keep in mind is that acceptance isn't always given right after the offer. So unless it's a written contract that both parties have signed, then the question of acceptance may not be so cut and dry. For a contract to be considered valid, it must be clear it was accepted. Another thing to consider is how long an offer is actually on the table once it has been made. The offeror is not obligated to extend the same offer forever. Typically, it's a good idea to include an expiration date on an offer, but if none is included, a reasonable amount of time is typically how long an offer is open. This may be 30-90 days depending on the industry. Remember, this is open to a court's interpretation if there is a dispute, so it's best to stipulate how long the offer is good for to ensure you don't have any problems. What's more, you are free to revoke an offer if an offeree hasn't responded and you wish to move on. However, if they accept it before you revoke your offer, you are legally bound to the original terms. Additionally, once you've agreed to allow an offer to remain open for a specified period of time, you cannot revoke it until that period has passed. Acceptance, counteroffers, and rejections. While a rejection is pretty straightforward, counteroffers are actually a special kind of rejection. Now, the offeror has to consider and either accept or reject the counteroffer. On the other hand, if the offeree accepts the offer, things are much more straightforward. However, depending on the type of contract, accepting an offer looks a little different. For example, a contract for a sale of goods requires acceptance of all terms. This is known as the mirror image rule. On the other hand, contracts for services, minor differences between the parties' beliefs about the terms may be deemed reasonable in a court of law. In general, the offeree can accept an offer in any of the following ways. 1. Fully performing actions or services based on the terms expressed in the contract. 2. Writing or stating their acceptance. 3. Making a promise to perform the services in the terms of the contract. 4. Performing improperly in accordance with the offer, say you delivered the wrong product, even though it's not the product in the contract. The fact you delivered denotes acceptance. As you may have already realized, it's a good idea to specify the terms of acceptance within the contract to ensure that there is no ambiguity around this. An exchange of value. The last part required for an enforceable contract is the exchange of something of value. Basically, one party agrees to do something and the other agrees to do something in return of equal value. This could be the sale of goods, or the rendering of services, leasing of property or equipment, etc. No, this exchange does not have to include money. Often contracts are put together where one party agrees to do something for the other party in exchange for free products, i.e. an endorsement deal.